It's a little warmer than -1 degree.
Where do you live?
Minnesota.
Wow. Thank you for joining me for the Module 2 live session.
No problem. Excited.
Great. This meeting is being recorded for the benefit of your classmates who couldn't be here and maybe watching it at home at their convenience. So this week we will be moving into the Uniform Commercial Code. Let's talk about our topics for this week. We are going to talk about the third element of a valid contract, which is consideration. We're going to learn how to create an intake form based on a written scenario or a legal case. We're going to rewrite contract terms based on an intake form. We're going to correct defective terms using an intake form, and we're going to research possible remedies for breach in a business contract situation. Let's get started. So our reading for this week is Contract Law for Paralegals, your textbook, chapters 3 and 12. The Restatement of Contracts, which is a treatise. It is a secondary source of law, like an encyclopedia. You only have to read chapter 4, and you can find that online by using Lexis Advanced, doing a search. And the Remedies and the Uniform Commercial Code, Article 2, Part 7. Someone asked me where you could find that, and I actually found that online doing a search on Google for the UCC. So, our introduction to the Uniform Commercial Code. Article 2 of the Uniform Commercial Code applies to contracts for the sale of goods. Last week we talked about service contracts, which would be personal services, could be like Britney Spears performing a concert, or Taylor Swift performing a concert, Alicia Keys performing a concert. That's a personal services contract. They exchange their service for a fee. We also talked about the roofing, the home construction, mowing someone's lawn. That's a personal services contract. Those are decided based on the law that is judge-made law at common law. This week, we're going to be talking about contracts for the sale of goods. Contracts for the sale of goods have a special law that is codified, a set of rules known as the Uniform Commercial Code, because we want the sale of goods to flow freely in the stream of commerce from state to state. So we want to uphold contracts for the sale of goods, and the UCC relaxes certain rules and provides special remedies for contracts for the sale of goods. What are goods? Goods are usually movables. If you buy a computer, if you buy clothing, if you buy shoes, if a construction company buys nails, buys doors, hammers, those are goods. So contracts for the sale of goods greater than $750 would be governed by the Uniform Commercial Code. Most states have their own version of the Uniform Commercial Code. So when you're in Minnesota, you want to look up Minnesota's UCC. You can find that on Lexis Advance. Again, the UCC has special rules for what remedies are available to buyers and sellers in the event of breach of contract. Usually, the parties to a sales contract have certain duties. One is a duty to perform the obligations that are specified in their agreement. Again, contracts for the sale of goods do not have to be in writing. A valid contract is one that has offer, acceptance, and consideration. Oral contracts are perfectly valid. I noticed some people miss this in the Module 1 assignment. An oral offer is valid. An oral contract is valid. Before people had pen and paper, they were bartering for goods, exchanging food for coins, exchanging food for work, exchanging labors for goods. So a contract does not have to be in writing. An employment contract does not have to be in writing. Contracts can be oral and they can be enforced. If there's a breach of contract, a judge will simply have witnesses testify in a court of law, and if their testimony is credible, then that evidence is just as good as documentary evidence. So, what are the parties' duties under a sales contract? So, if we have a contract for sales, say, Shauna, if I am selling you my computer for $500 and you agree to buy the computer for $500, what is my obligation or duty under that contract?
To sell the computer for $500.
Okay, delivery, I would have a general obligation as a seller to transfer title and deliver the goods to you. Title is the ownership interest in goods or property. So I would have to deliver and deliver the goods. And your obligation to me would be what's called tendering payment, and that's offering payment at a reasonable time. So those would be our obligations. The seller's obligation is to transfer and deliver the goods. The buyer's obligation is to accept and pay for the goods. When one party breaches a sales contract, the UCC provides the injured party with a variety of pre-litigation and litigation remedies. These remedies are designed to place the injured party in as good a position as if the breaching party had actually fully performed their contractual obligations. So, if one party breaches a sales contract, the UCC provides the injured party with a variety of remedies. For example, a contract for the sale of goods. If the seller delivers the goods, the buyer doesn't pay for them, the seller can sue for breach of contract. The buyer's breach would be the failure to pay. The remedy in that situation would be what? If a seller tenders and delivers goods and the buyer accepts them but doesn't pay for them, say, Shauna, if the seller goes to court and sues for breach of contract, what would be the best remedy? So in a scenario where a seller delivers and tenders the goods and the buyer does not pay, the seller can sue for breach of contract. And the best remedy in that situation would probably be money damages in the form of the contract payment. If it's a contract for the sale of a computer, the seller delivers the computer, the buyer doesn't pay for it, but it keeps the computer, then the best remedy might be money damages, which would be the contract price to put the seller back in the same place as if the contract had been perfectly performed. And those would be known as either expectation damages, or compensatory damages. So you want to put the non-breaching party in the same position they would have been in if the breaching party's contractual obligations were fully performed. You can find this in UCC sections 1-106, or if it is if it's a lease agreement, it would be 2A 401. Let's talk a little bit about the seller's performance. Is a tender of delivery. The seller has to transfer and deliver goods to the buyer or lessee in accordance with a sales or a lease contract, as is the seller's or lessor's basic obligation, UCC 2-301. Let's talk about the lessor. If, for example, some people lease an automobile rather than buying it. Some people lease furniture rather than buying the furniture, right? You might rent to own it. In that case, you'd be the lessee, and the person who owns the goods but is leasing it to you would be the lessor. So the lessor still has an obligation to transfer and deliver the goods in accordance with the sale or lease under UCC 2-301. The tender of delivery requires the seller to put and hold non-conforming goods at the buyer's disposition and give the buyer any notification reasonably necessary to enable delivery of goods. Parties may agree as to the time, place, and manner of delivery. Let's talk about cure. The UCC gives a seller or a lessor who delivers non-conforming goods an opportunity to cure the non-conformity. Although the term cure is not defined by the UCC, it generally means an opportunity to repair or replace defective or non-conforming goods. So, in a contract for the sale of goods, if the seller sells an automobile and the buyer has purchased a gray BMW, if the seller delivers a black BMW, that would be non-conforming goods. Under the UCC, the seller, after getting reasonable notice from the buyer, has an opportunity to cure the defective delivery by finding conforming goods, fixing the non-conforming and goods, and re-delivering. So a cure may be attempted if the time for performance is not expired and the seller notifies the buyer of his or her intention to make a conforming delivery within the contract time. And if you want to make this more specific, you can write in the contract that the seller has 20 days to cure any non-conforming delivery. So suppose this is a contract for the delivery of an advertising, a set of advertising billboards. Maybe 10 of the billboards are conforming, but the other 10 billboards are not. Then the seller would have an opportunity to cure that by fixing the billboards and making another delivery within the contract time or within a reasonable time. If the buyer does not give the seller an opportunity to cure, that could be a breach of contract. Once the seller has properly tendered delivery, the buyer is obligated to accept and pay for the goods in accordance with the contract. And if there is no written agreement about how to properly tender performance, then the UCC provisions control the transaction. So it's very important for you to read the Uniform Commercial Code. The right of inspection. The buyer has a right to inspect goods that are tendered, delivered, or identified in the sales contract prior to accepting or paying for them. If the goods are shipped, the inspection may take place after their arrival. If the inspected goods do not conform to the contract, the buyer may reject them without paying for them. So the buyer does have a right to inspect the goods and make sure that they actually conform. And if the goods are broken, suppose it's a contract for the delivery of wine and the vineyard ships wine to a restaurant. If the restaurant inspects the good and finds that a case of wine is broken, then the buyer can reject them without paying for them because they're non-conforming goods. When the buyer does accept the goods, they must be paid for. That's UCC 2-607. Unless the parties to a contract agree otherwise, payment is due from a buyer when and where the goods are delivered, even if the place of delivery is the same as the place of shipment. So the place of delivery is usually where payment is due at the time the goods are delivered. The buyers often purchase goods on credit extended by the seller. Unless the parties agree, the credit period begins to run from the time the goods are shipped. Not the time they're received, but the time the goods are shipped is when the credit period begins to run. If it's a lease, a lessee must pay the lease payments in accordance with the contract, and that's UCC 2A 516. So UCC 2, Article 2 applies to contracts for the sale of goods. If it says 2A, those would be the lease agreements, lease contracts. The rules are under 2A. Excuse me, the remedies. So a buyer who has accepted goods may revoke his or her acceptance upon inspection when they find that the goods are non-conforming, or the non-conformity substantially impairs the value of the goods to the buyer. And one of the four factors is shown. The seller's promise to timely cure is not met. The goods were accepted before the nonconformity was discovered, or the nonconformity was difficult to discover, or if the goods were accepted before the nonconformity was discovered and the seller had already assured the buyer that the shipment was conforming. So a buyer who's already accepted goods may revoke the acceptance if a later inspection shows that the goods are non-conforming and the non-conformity was difficult to discover at the time the goods were delivered. What other rights do the sellers have under the UCC? Well, the delivery of goods may be withheld if the seller is in possession of them at the time the buyer breaches the contract. For example, if the seller finds out that the buyer is insolvent, has filed bankruptcy, or is behind on payments for past orders, the seller may withhold delivery of the goods if the seller is in possession of them when the buyer breaches the contract. This remedy is available if the buyer wrongfully rejects or revokes acceptance of the goods, fails to make a payment when it's due, or otherwise repudiates the contract. If part of the goods under the contract have been delivered when the buyer materially breaches the contract, the seller may withhold delivery of the remainder of the affected goods. That's UCC 2-703. A seller who discovers the buyer is insolvent before their goods are delivered may refuse to deliver as promised unless the buyer pays cash for the goods. That's UCC 2-702. Any questions? I know we're going through these UCC provisions quickly, but they are discussed in your reading, so take the time to review them and get familiar with them. What are the buyer's remedies? Well, the UCC provides a variety of remedies to a buyer upon the seller's breach of a sales contract. One is the right to reject non-conforming goods or improperly tendered goods. The second is the right to recover goods from an insolvent seller. The third is the right to obtain specific performance. So, for example, if the item that is being sold is rare, for example, a Monet painting is very rare. So if the buyer is purchasing a Monet painting and the seller refuses to deliver the goods after a contract's been performed, the buyer can sue for breach of contract and ask the court for the remedy of specific performance, saying, look, I don't want money damages because the item that I am purchasing is so rare that the only way to make me whole after this breach is to order specific performance of the contract, in which case, if the court orders the seller to comply with the contract and deliver the goods, the seller refuses to do so, that's contempt of court, and the individual can be put in jail until they cure the contempt of court. So a specific performance is usually used to obtain possession of works of art, antiques, rare coins, and unique items under UCC 2-716. What other remedies does a buyer have? Which is the right to cover, okay? So if you are a restaurant and you have purchased a shipment of 50 cases of wine and the seller does not deliver after a reasonable time, the time for delivery has passed. The buyer may obtain substitute goods from another vineyard, right? If you're a restaurant and your customers like to drink wine, if the first supplier failed to deliver 50 cases of wine, you can contact another supplier and have them ship the goods. That would be the right to cover. And in any event, if the cover is more expensive than the contract price, you can sue for damages. That'd be compensatory damages. So if the buyer has to pay more for the substitute goods from another seller, The buyer can then sue for money damages to be put back in that same position as if the original contract had been perfectly performed. The buyer has a right to cancel the contract, perhaps if the finding that the seller is insolvent, and again, sue for money damages. So it's very important for the quiz that we're having next week that you know the buyer's remedies. So study this slide. Here's a summary of the UCC remedies. You want to study that slide. Let's talk about your Module 2 written assignment, Shauna. It's on remedies. Let's consider the following scenario. The buyer and seller have a master contract that is complete and enforceable. 20 customized parts have been ordered from careful seller by the buyer. The price is $1,000 per part. They're customized with painted advertising for the buyer's needs. So 20 customized parts are being sold by careful seller to the buyer. They are customized and painted for the buyer's needs. 20 parts are then shipped to the buyer. The buyer accepts 10 but rejects 10 and doesn't pay for any of the parts in your scenario. The buyer held all the parts for 10 days and then returned the 10 rejected parts with a message saying they are too large and that the buyer intends to use the acceptable ones and then obtain cover for the other 10 parts from a different company. The seller has the right to cure any defect in parts within 10 days of notification of the defect to the seller and the return of the defective parts. If the seller does not cure within 10 days, the buyer may obtain cover parts from any other source. This paragraph is not intended to add or change a UCC remedy other than to give time limits. So that is how the contract reads between the parties. Now, here is what you need to do in your Module 2 memo. Define cover and cure in your own words. What do the UCC remedies of cover and cure means? And then cite to the UCC provision that you are paraphrasing. And you may choose to cite to the UCC provision in your state, which you can find by doing a search on Lexis Advance, looking up statutes in your state, whether you live in Texas, Florida, Illinois, Minnesota. Go on Lexis Advance, search under your state or your state's legal sources, look under your state's code, which is the statute book of written laws, and look under your state's UCC provision and get the definition of cover and cure. The next part of your assignment, complete the italicized portion of the IRAC table, just like you did in Module 1. There is another IRAC table. Using this scenario, use the UCC and the details of the contract to complete the table. And then select a way to fix Clause 3 of the master contract to make it more clear what the parties' duties are under the contract, and then explain why you made this fix. Be sure to cite two sources. You should cite to 3 primary sources in this assignment, which could be cases or UCC provisions. Follow the Indigo Blue Book format and use in-text citations. Now let's talk a little bit about the method of IRAC as opposed to the country Iraq. IRAC is an acronym in which each letter stands for a concept, issue, rule, analysis, conclusion. IRAC is a way to analyze a legal problem that's used by law students and lawyers everywhere. The use of IRAC is also popular among judges. It is a way to show application and analysis in a very clear way. Begin by reading facts to determine the main issue. Complete research to determine a rule. The rule must have an acceptable source that must be cited. The analysis is when you apply the rule to the facts of the case. You may find that the rule doesn't really work. If it does not, then say that. Then try a new IRAC with a rule that does apply. Missing facts called fact gaps should be typed into the application and analysis part of your IRAC. Type the facts that still need to be sought. The conclusion is the last part of your analysis, and it simply asks the issue question. So in this case, the question might be, in our scenario, was the seller given a reasonable opportunity to cure? The cure rule would be the UCC provision on cure. The analysis would be, when you take the facts of our case, you look at the buyer's rejection of 10 of the items, and the fact that the buyer kept 10 of the items, and then the buyer went to cover without giving the seller an opportunity to cure. And then you can find out whether or not the UCC provision on cure, or whether the contract provision on cure, was violated by the buyer's conduct in our scenario. And then the last step is to answer the issue question. Complete an IRAC analysis using the form that's been provided in Module 2. You want to download that form, fill it in using the applicable UCC rules on cure, and then add your conclusion. So this is really where we're working on showing you how to do the IRAC form, how to analyze things using issue, rule, analysis, conclusion. And if you've completed the form, you can write this up also in a memo that is double-spaced and includes in-text citations. Be sure to read all of the lesson notes for Module 2, contract remedies for business cases, the importance of grammar and language, name the error, and spotting errors. So I am going to open up, I'm going to share my web browser with you. We will go into the online classroom. And take a look at some of the other concepts that are discussed in Module 2. Let's talk about the importance of grammar and language. Whenever you're writing, you always want to use correct grammar. You want to use consistency. You want to make sure you are using the correct term of words. You want to avoid redundancy in your writing. If I say it was a very cold, frigid, and snowy night, cold and frigid really mean the same thing, so you could take one of those words out. If I say the fire was very red hot, there's a little redundancy there. You could just say the fire was hot. If we say Jim and Jane walked across the street, you want to make sure that you use the correct tense of the word. Jim walks across the street. They walk across the street. So when it's a singular person doing something, Jim walks across the street, then your verb would end in S. If it is plural, Jim and Jane walk across the street, then your verb would be not end in S. If you were showing a possessive word, Jane's book, you would add an apostrophe S to Jane's book. You don't say Jane book, you say Jane's book. apostrophe S. That is to show a singular possessive form of the word. So you want to make sure that you've gotten your grammar down. One way to do this, of course, is to sign up for Grammarly. I would encourage all of you to use Grammarly. So when you're writing, you're checking your grammar. You can also check your grammar in the Microsoft Word editor. For more information, you can check out the grammar book, free quizzes to help you check your rules of grammar, your punctuation rules. Verb subject agreement is where I see a lot of students making a mistake. A singular subject takes a singular verb. Bill goes to the park. They go to the park. So you want to make sure that you are using the correct tense. Either or is singular. Neither Juan nor Carmen is available. You would not say neither Juan nor Carmen are available. Neither is singular. My aunt or my uncle is available. Singular. Either Kiana or Casey is helping me today. You would not say they helping me today. In that case, if it's plural, you would say they help me today. So these are some of the rules of grammar that you would want to review, because when you're writing, judges and lawyers expect you to already have perfect grammar. I found that out when I was practicing law. And if you're a paralegal, your supervising attorney will take you aside and say, you need to fix your grammar here because we can't submit this brief to the court with these grammatical errors. So you want to take a few moments and learn how to spot errors. Here is a knowledge check. Let's take a few moments to go through our knowledge check of grammar. Which of the following is correct? Paul's payments under the contract are to be made. Paul's obligations under the contract are to make the payments, or Paul's payment obligations under the contract. Paul's obligations under the contract are to make the payments. I got that right. They're tricky. Select this for more information. All right, this is correct. That'd have been terrible if I missed one. Okay, and the next one, which of the following is correct? The contract was not completed. Joe is asking for a remedy. In the near future, Joe will sue. The next one, the contract will not be completed. Joe asked for a remedy. That's wrong. It would be asks. So that one's wrong. The third one, the contract was not completed. Joe is asking for a remedy. In the near future, Joe was sue on, no. So number one is correct. All right. Question 3. Which of the following is correct? Dale and Lisa are asking for an appointment. They are asking for an appointment. That's correct. Dale and Lisa be asking for an appointment. We do not use ebonics in here. Dale and Lisa is asking for an appointment. No, that is correct. That's incorrect because Dale and Lisa is plural and is asking for is singular. So the first one is correct. Dale and Lisa, they are asking for an appointment. Okay, let's keep going. Number 4, which of the following is correct? Fred's painting will paint the building. Fred's painting. So that sounds like a business because the word painting is capitalized. Fred's painting, that would be a proper noun. Okay, the next one. The service is Fred's painting of the building. The last one. The service is by the painter of the building, named Fred's painting. I'm going with the first one. They're tricky. They're tricky, even for your old teacher. All right, number 5. Which of the following is correct? Ralph, Margot required to complete the repair on time. That is not correct. You would need a conjunction between Ralph and Margot. So Ralph or Margot is required to complete the repair on time. That's singular. Or Margot is required to complete the repair on time. Number 2 is correct. The third one, Ralph or Margot are required. No, are would be if it was they, if it was plural. So this is the one that's correct. Got that right. All right. Last but not least, which of the following sentences is correct? Promises of Margot relying on by Ralph. That is not a complete sentence. Ralph is relying on the promises of Margot. That is a complete sentence. Relying on the promises of Margot, Ralph is. That's how they speak in Europe. This has a subject, Ralph, is relying on. That's your verb. Promises of Margot is your object, predicate. That's correct. Perfect. If I can get all 6 right, you can get all 6 right. So be sure to do that knowledge check, because when you have your upcoming quizzes in Module 3, there will be grammar questions. Great. So let's get back and wrap up this Module 2 live session. Thank you so much for being here with me. So the live session question for Module 2 is, what does UCC 2-712 say? You can Google that, pull up UCC 2-712, and simply drop that answer into the live session assignment box for Module 2. In order to get credit for the live session for Module 2, you must submit the correct answer to the question, what is UCC 2-712? That answer is due Sunday, January 16th. Your Module 2 written assignment is also due Sunday, January 16th. It is a scenario that we discussed, completing the IRAC table, analyzing the scenario involving the seller's right to cure. If you have any questions for me, I'm only an email or a text message away. Some of you have already called me and texted me. That's great. My number is 702-241-3415. I'm always available for your needs. You can always call me and get an answer to your homework questions. You can also call tech support. Rasmussen personal support is excellent, helping you with your computer, helping you with your files, helping you upload assignments. They're great with that. And I hope everyone has a terrific week. I will see you all in cyberspace. Thank you, Stashana.
Thank you. Have a good night.
Have a good night.